Hello and welcome to the fourth in our series that is normally looking at the dark side of AI, or the possible, should we say, dark side of AI. And today we'll be dealing with AI and copyright, something to my mind which is one of the most fascinating topics that we are addressing in this series. I am delighted to have Robert Mahari here today. Robert is originally from Switzerland. He studied law at MIT. He's now doing a joint doctorate, both in D Juris at Harvard Law School, and also a PhD in MIT Media Lab, somewhat unusually. So an extraordinary combination of kind of backgrounds. And I also have a contribution from Jessica Fjeld, who is teaching in Harvard Law School, who is unable to be here today, but we pre-recorded something. And I can just say that it was really very fascinating. I obviously know what it is, so we will have her in spirit in some senses. And today really is a chance to look at something and to involve legal experts. I have to say that I've been a huge fan throughout my career as a student as well of legal minds and the incisiveness of the legal mind. And whatever we might think from the world of, let's say, the creative arts, there nothing substitutes for the precision and accuracy, the experience, as it were, of our legal mind itself. So I'm really grateful to have Robert with us today. So just to say, I want to say just a few words by way of background. So firstly, this is part of a series. We've got two more sessions. Next week, we have a session about the AI and the operation, the Office of the Future, with some very distinguished people, including the president of the AIA and hopefully the president of the RIBA as well, along with some of the experts from legal firms, from some architectural firms such as Foster and Partners, and also Wan He, who's a leading software developer for architects. So that should be a fascinating thing. And finally, we end up with Blazer Wirli-Arkas, who has been working for Google and one instrumental in supporting the arts, set up Google AMI, Artist Machine Intelligence Group, curated the first ever exhibition of AI generated art, and is a less dystopian figure, shall we say, in this debate, where there are clearly two sides about whether or not we should be worried about AI. So last week we had Aaron Hertzberg with us and Morgan Frank. This was, I thought, I mean, the feedback was astonishing. People really enjoyed this particular session. Aaron and Steve Epstein were responsible for setting up an article, for writing an article, and including in that article the opinions of a whole, about 20 or so individuals, which including Robert and myself, and also Memo Acton, who has been part of Digital Futures and the Digital Futures Award winner this year, and just basically going through the article itself. Morgan Frank was doing a PhD in MIT Media Lab and is now University of Pittsburgh, and he's interested in the future of labor and offered, I think, a much more kind of balanced or nuanced approach to the question than well, we had a very polemical session, which was great, I think, with Martin Ford, and I think Morgan was able to balance that out. So we're really looking at whether or not we should be concerned about these things. Maybe it should be the dark side of AI, question mark. But this certainly was a way of introducing the theme. And the article itself that came out in Science was, I think, a hugely significant and timely contribution to the debate, laying out some of the basic principles, but really offering essentially an overview of a vast topic. And it was very, very condensed. And I think really what these follow-up sessions allow us to do is to unpack some of these questions and explain them, because there is so much here. I would say to Aaron and Steve, this should be a book. Every single contribution could be a chapter in a book. It's a really broad topic. And what I really appreciate about this particular group of individuals was that everyone came from a different background, but with a particular expertise. So it was a very inclusive discourse. I just wanted to mention that there has been even early on an important issue to do with copyright that came out with this particular AI-generated artwork that was was famously auctioned at Christie's in New York and fetched a pretty surprising figure of 2000. Back in 2018, before even the world of architecture had really been engaged with this was the first GAN-generated work of art by the Paris collective, Obvious, the title being Edmond de Bellamy. And what this basically did was raise some issues very early on about the question of copyright, who was responsible in some senses for the work of art. Was it obvious, or was it the person who wrote the code, whose code they used, and so on? And I think to begin with, this was one of the early kind of case studies, as it were, that really began to sort of point to the fact that attribution was going to be a complex thing. And what I discovered in my research, which is only a superficial architect view of research, is that within copyright law there were differences between different countries. In France, for example, where Obvious operated, computers could not claim copyright, something that I think hopefully will address again later today. Whereas under British law, the copyright rests with the person by whom, I'm just reading from my text here, the arrangement necessary for the creation of the work are undertaken, which would seem to suggest that actually Obvious would, under that definition, would be responsible in some senses. But it was very unclear. And I think this was interesting because it raised a lot of issues early on about that were going to come to the forefront. And also, before that even, the question about digital property had been raised in an issue of architectural design that was guest edited by Wendy Fock and Antoine Picon. And this is unfortunately a journal, a magazine that actually is finishing soon. It's a real tragedy because it's been a very important voice, but we've come to the end of the run. And this was a very important contribution. I was asked to write the concluding comments, as it were, the counterpoint essay, as it were, where I guess they expect people to kind of argue the opposite. And my line of thinking, this is the first page of it, was to say, well, actually, hold on a second. Let's not forget the fact that copying is intrinsic to human culture. And in my own book on camouflage, which came out with MIT Press, I was pointing out that in fact the culture of the meme, and the meme was actually originally coined by Richard Dawkins in his book The Selfish Gene, talks about how things, in a sense, spread horizontally as opposed to the kind of vertical transmission of culture. They spread horizontally, and it's how culture propagates itself. Things catch on, tunes, expressions, fashion, and things by a kind of culture of replication. And without going into that in any more detail, I would simply say, quote Adorno, the human is indissolubly linked with imitation. A human being becomes human at all by imitating human beings. Well, I'm not quite sure whether these kind of comments stand up to anything in the world of copyright law, but nonetheless, as a provocation, I was kind of commenting, well, let's hold on a second. Let's not forget that we humans are based on, much of what we do is a form of imitation, and that's the way in which we propagate culture in some senses. The issue, of course, has been whether or not AI replicates something, and this will be something, or directly whether it takes material and simply repeats it. And all I would say, just as a kind of a prelude to a discussion today, is that in my own work, when I've been working with Midjourney, I don't think that AI copies in any way. I did one particular exercise where I generated probably about 5,000, I don't know, because these things, you can generate a lot, generated about 5,000 images on the theme of Mies van der Rohe's Barcelona Pavilion. And this is one of the outcomes. And you can kind of see that broadly, it kind of takes something, let's say, in terms of its outlook from the kind of language that's in the Barcelona Pavilion, but it's nothing that actually directly replicates anything. It's kind of almost like it's treated as a kind of shape grammar in which you get variations of a theme, but never once in these 5,000 iterations or outputs that it came up with, outcomes, did we ever see a replication of Mies van der Rohe's Barcelona Pavilion, which, by the way, is an interesting thing in itself, because it is a reconstruction of a building that was taken down shortly after it was the exhibition finished. A reconstruction which didn't use the same materials. They found some other sources, but they put it together. And the argument was that it was the idea they were presenting, that they were re-articulating. It wasn't copying the original. It was a re-articulation of the design itself. But the question really is thrown into perspective by the arrival of DALL-E 2. This is one of the kind of iconic images when this diffusion model burst onto the scenes only last year, only in 2022. And you can see it's based on prompts, and this particular prompt, an astronaut on a horse, doesn't copy anything, in the sense that I don't think there's been an astronaut riding a horse, and if there has, I don't know if it's been photographed this way. The point being, what, to my mind anyway, AI does is search and synthesize. It picks out features, it re-articulates them, but the way in which it operates, of course, is very, very difficult to follow. A neural network is a black box. We really don't know what's going on there. But certainly, there are many examples that will show that there is no direct copying. Anyway, this is the article, just an article that we read. I'm just wondering, maybe I could just briefly read through what we said. Because it's not difficult. I'll really read it out, because it's very difficult to see on this screen, but I can read it out. So I'm going to start down the bottom here. Generative AI's reliance on training data to automate aspects of creation raises legal and ethical challenges regarding authorship, and thus should prompt technical research into the nature of these systems. Copyright law must balance the benefits to users of generative AI tools and society at large. Law could treat the use of training data as non-infringing if protected works are not directly copied, fair use if training involves a substantial transformation of the underlying data, allowed only if creators give an explicit license, or subject to statutory compulsory licensing that allows data to be used for training, provided that creators are compensated. Much of copyright law relies on judicial interpretations, so it is not yet clear if collecting third-party data for training or mimicking an artist's style would violate copyright. Legal and technical issues are entwined. Do models directly copy elements from the training data or produce entirely new works? Even when models do directly copy from existing works, it is not clear whether and how artists' individual styles should be protected. What mechanisms could protect and compensate artists whose work is used for training, or even permit them to opt out while still allowing new cultural contributions to be made with generative AI models? Answering these questions and determining how copyright law should treat training data requires substantial technical research to develop and understand the AI systems, social science research to understand perceptions of similarity, and legal research to apply existing precedents to new technology. Of course, these points present only an American legal perspective. A distinct legal question concerns who can claim ownership over model outputs. Answering this requires understanding the creative contributions of a system's users versus other stakeholders, such as the system's developers and creators of the training data. AI developers could claim ownership over outputs through terms of use. By contrast, if users of the system have engaged in a meaningfully creative way, for example, the process is not fully automated or does not emulate specific works, then they might be considered as the default copyright holders. But how substantial must users' creative influence be for them to create ownership? These questions involve studying the creative process of using AI-based tools and may become more complex if users gain more direct control. I mean, I think this was an astonishing kind of overview of the situation. And as you can see, there are many, many questions there. And I think this is a very nuanced article where it's, in a sense, fairly open-minded. But I think we're at a point where this is really becoming quite an issue. And obviously, since this article, there have been a number of issues, lawsuits and so on, regarding AI and copyright. I'd like to invite Robert to maybe say a few words about the kind of the motivations and the thoughts that went behind this very, very nuanced series of paragraphs looking at the law, and to reflect on what was the kind of driving force behind the thoughts in this particular piece. So welcome, Robert. It's great to have you here, and thank you for this incredible contribution. I think it was a remarkable contribution and a remarkable article.
Perfect. Well, thank you so much, Neil, for the introduction and for reading. I think that's quite helpful. Now that was, the entirety of the legal discussion in this article, which is funny when you think about the fact that law review articles usually number, in dozens and dozens of pages. So to provide a little bit of a kind of a background, like where we started with all of this, I think we started, or at least I started my thinking about, how does AI, generative AI, relate to prior forms of kind of artistic expression, and are there analogies that we can draw on? And it's funny because in the end, the kind of main analogy that informed a lot of the discussion that did make it into the paper was left on the cutting room floor, which is the analogy to photography, right? Where you now have this kind of technical intermediary that is, on the one hand, in a kind of mathematical or chemical fashion, fixing reality. It's deterministic. The process is not necessarily understood by the photographer. And when photography first came out, there were questions about whether photographs should be considered as copyrightable kind of expressions. And the conclusion was, at least in the United States, fairly quick. The photographer is really kind of this mastermind that thinks through the composition and the various other kind of artistic dimensions of her photograph, and so by that logic, the expression ought to be so the photograph should be copyrightable. And so then we tried to apply that kind of logic to AI, and we said, okay, well, we have this technical intermediary, this artificial intelligence in between. The users don't necessarily understand exactly how it works. It's actually quite hard to do that. But the users, the prompters of the AI, can invest considerable kind of creative effort into how they're prompting the machine, and gain outputs that appear to be fairly creative and kind of new. And that ought to probably enjoy copyright protection, although that's not necessarily what we're seeing play out. The other kind of big theme for thinking through that is to really try to get a good sense, a good grasp of the full kind of AI process. And what I mean by that is, you have training data that's created by people who, unbeknownst to them, are contributing to the training data. Then you have a process of training an AI, and there's this question of like whether before you generate any outputs, right, is the trained AI or the process of training an AI, is that violating people's copyrights? And if so, why or why not? And then finally, you have the process of kind of prompting and generating outputs. And so we try to base the legal analysis on kind of the practice. And it turns out since this article that the practice has become even more complex. And so I'm happy to talk about some of the kind of ongoing work we've been doing since then. But I hope that serves as a good kind of introduction.
Yeah, no, it's interesting because I also my starting point in terms of copyright was to pick up on photography, and especially the kind of comments of Walter Benjamin on the loss of aura in the age of mechanical reproducibility. I should say that my book was called Architecture in the Age of Artificial Intelligence, so there was an explicit reference to them. I just wanted to throw out something there as well, just as a thought to kind of follow on from, and we'll come back to it later. But to say that what tends to happen in architectural culture, this was kind of in a way was established by one of the AI researchers who developed a particular neural network called CAN, Creative Adversarial Networks, was that there is a canon to everything that we do, in a sense that, if something, unless something conforms loosely to the canon, it's not perceived as being an artwork, in the sense it has to be, if it's going to be a modernist, minimalist artwork, it's got to at least be part of it, at the same time nudging the boundaries and taking it somewhere further. And certainly in architecture, it's almost like there are certain figures who set the scene. And there's some famous architects out there. We know who they are. Zaha Hadid, well, no longer with us, of course. Rem Koolhaas, Frank Gehry, who MIT, of course, know very well, and so on and so on and so on. And these are the ones who kind of, as it were, call the tune. And if you're a student of architecture, you've got to somehow fall into that canon and do something that at least acknowledges what that area is, without doing something completely outrageous. Because if it's too far outside that canon, then in some sense it's not seen as architecture. It's got to be somehow subscribing to, but not directly replicating, the work of these particular masters. I'm just wondering, Robert, maybe the best is the time to probably bring to show Jessica's comment. I've got some. She gave about 12, 13 minutes, which actually is very super interesting, reflecting precisely on this kind of question of what has happened since that article, because what we're in a territory where things are happening rapidly, and they're speeding up according to Moore's law. Things are happening faster and faster and faster, and anything that comes out is almost entirely out of date by the time it's actually been published. So I'm going to just kind of quickly play the piece with Jessica, which I pre-recorded. Jessica unfortunately can't be here today, so this is Jessica.
Thank you for having me today. My name is Jessica Fjeld. I am a lecturer on law at Harvard Law School and a senior advisor at the Berkman Klein Center for Internet and Society. So in the aftermath of the paper that we published in Science about AI and art, there have been a real rash of lawsuits, mainly by individual creators whose works have been scraped to train AI data sets, to create data sets to train AIs, I should say. And it's really left me thinking about, something that we sort of gesture at in the beginning of the paper, which is that, fundamentally, a lot of the turmoil in this space is about existing creators, people who have built their livelihoods in these spaces, having those livelihoods threatened by new tools that are going to change, perhaps to some degree, how their industries operate. And I have to say, it's a little bit depressing to follow these lawsuits, because many of them have been filed here in the US, in my home jurisdiction, a few also in the UK that I'm aware of, and I imagine there are others around the world. But most of these companies are headquartered in the US, UK, maybe EU. And so most of the lawsuits are going to happen, where the companies are subject to jurisdiction. And here in the US, all copyright lawsuits are federal lawsuits, which means that, according to a study I looked at a couple of years ago by a trade association of intellectual property lawyers, the kind of minimum cost of entry to prosecute one of these lawsuits is in the six figures, right? And it can go up easily from there. And beyond that, the US federal court system is incredibly backed up, and it takes years. And so when we're thinking about, I think that I've been interested in the copyright questions around art and AI for a long time. But when we're thinking about it really in terms of the livelihoods of creators, how artists are able to get paid for the work that they do, it is hard for me to see copyright as a decent solution. It's going to take an incredible investment of money up front, or finding lawyers who will work on a contingency basis. And it's going to take years, right? And in the meantime, these people have families. And if they are not already headquartered in the US or UK, they have all of these additional barriers to, sorting out the legal system, finding attorneys, outside of their home jurisdiction. And it's just it leaves me pretty cold. It leaves me without a sense that, even if creators get the kind of recovery that they're looking for in these lawsuits, that it's really going to be, a viable solution over time. I think when we think about copyright and these kinds of licensing schemes that end up working out on a broad scale, you can think about Spotify, for example, right? Previous to Spotify, we had a robust, and continuing, but less popular. We had a robust trade in so-called pirated music, right? MP3 services like Napster that allowed people to trade music that they had files of without paying any royalties to the artists or the labels. And Spotify is an improvement on that, but right, each stream is just fractions of a cent. And so fundamentally, I'm like, even if they win and they get some kind of initial award or succeed in establishing some kind of licensing scheme, are artists whose works are used to train AI fundamentally going to be in the same place that artists now are with Spotify, where it's only, the Beyoncés of the world who are making money? And God bless Beyonce. She deserves every penny she gets, but Spotify is not a living wage for smaller acts and smaller touring musicians. And that leads me to a place where I'm like, I think the solution in terms of supporting artists through significant cultural and technological change is direct government support of artists. And there are jurisdictions that do that, including Germany and others. And I think that, if, in our cultures, in our jurisdictions, if we value having artists, we probably need to make direct investments in them rather than expect them to bring and follow through on and recover through copyright schemes. So it's a little funny maybe for an IP expert to say that I've not got a great deal of faith in the copyright system to bring about the ends that we want, but that's where I am. I also think a piece that's probably worth unpacking, since we had pretty limited space in the article in Science, is why the outcomes of these lawsuits are so uncertain. And here I'm speaking specifically to the ones that are brought in the US. So as many of you probably know, copyright law is territorial. So it really is country by country as to what the protections are. Now, there is a sort of a treaty that sets a baseline called the Berne Convention. So you see a lot of commonalities between copyright laws and reciprocal protections. So where you have a work that is protected by copyright in one jurisdiction under the Berne Convention, it'll be protected in other signatories to the convention as well. But that said, there is still some variation in copyright law country to country, and probably the biggest exception is that only the United States has this concept of fair use. The UK and Commonwealth countries, many Commonwealth countries have a related concept called fair dealing. So sometimes you see them lumped together as fair use and fair dealing, but fair dealing is a much narrower set of exceptions to copyright law that provides for non-infringement in cases like education. Fair use is a much broader and more flexible concept, which has its real advantages in terms of allowing a kind of safety valve for copyright to evolve over time and respond to changes in technology and culture, but also has the problem that because it's such a flexible standard, it's really subject to interpretation by courts. and things can come out in surprising ways. Meaning that for all of these generative AI copyright lawsuits, we are really going to be waiting until, I would say, it would shock me if it was in 2024, probably more like 2025 for judgments. And each judge who is hearing one of these cases, each court which is hearing one of these cases, may come out differently. We may end up with a bunch of inconsistent decisions that leave us every bit as unclear in 2025 as we are here in 2023. How that standard works. So what are judges looking at when they're thinking about whether scraping data for a generative AI algorithm is fair use in US copyright law? There are 4 factors. Courts evaluate all of these factors. It's not a counting exercise where if you win 3 of them and lose 1, you automatically win. You could have just 1 strong factor, but have it be so strong that you still win. So courts ask about the nature of the copyrighted work. So is it more creative or less creative, more factual? There's less protection for factual works. More creative works get more protection. So finding a fair use is more likely with a more factual work. They ask about the purpose and character of the use. So they ask about, is the use more educational? Is the use perhaps critical of the underlying work? Is it perhaps a parody, something like that? Courts have found strong protections there. They ask about the extent of the taking, right? Both, did someone take a lot of the work, and did someone take the kind of heart of the work? There's a great example in terms of the heart of the work where a newspaper published an excerpt from a forthcoming book. It wasn't the whole book. It was only a piece of the book, but it was the kind of core revelation of this new nonfiction book. Therefore, sort of spending some of the energy that consumers might have had to buy the book. And so that was found to be not fair use. I've lost them now. Purpose and character of the use. Effect on the market, the last one. So the question is, what is the likelihood of this use to have as an effect on the market for the copyrighted work? So at a high level, when we're working through these, we can see that, scraping data sets for training AI, on the one hand, might look like some other cases that have gone well in terms of fair use findings. For example, Google Photos. Google was sued when they launched their image search because they would copy the images that they were indexing for search and create a little thumbnail. So when you load up your Google image search results, you'll find those little thumbnails. And those little thumbnails were scraped from the images that Google has indexed and are delivered to you from Google servers, right? So they are a copy. Now that was found to be fair use because the court said it doesn't have an impact on the ultimate photo. It's just an indexing tool. It serves a different and transformative purpose. So you might say, this is, if we're scraping images to train an AI algorithm, that's sort of like Google search, right? Google image search. We're not using the images for their original purpose of, look at this photograph of a mountain in Pakistan. We're using the images to train an algorithm. That's totally different, and it should be fair use. On the other hand, you might say, hey, this is a reproduction of the entire work. There is a licensing market for these works, right? When people want to use them for films or to illustrate things on their website, they pay for these images, and therefore, the factors should weigh in favor of a finding of no fair use, and that this is infringement, and people are under U.S. law entitled to recover for damages for the infringement of their copyrights. So it's a complex question. I don't think, in spite of the many very confident talking heads out there, that anyone knows how these cases are likely to come out. Fair use is littered with surprising decisions, some of which were reversed and others of which have stood the test of time. And I think that sort of underlines why copyright is such a risky mechanism when we want to think about how to take our artists and creatives through a time that is going to be challenging for them and for their industries and their livelihoods.
That was, I think, a beautiful contribution from Jessica, and it almost raises more problems than it does solutions to it. Maybe just make a couple of points that for the IP is intellectual property. Maybe architects and designers are not so aware of the term. I also thought, I want to ask Robert what his thoughts on that are, and so as well. But just to say that there's in terms of the use of mimicry as a form of parody. The key person is Homi Bhabha, at least to my mind, in the theoretical context, who is herself at Harvard, who raises this, particularly in the context of colonialism, how you could replicate something with a degree of irony as a way of mocking in some senses. You see this in cartoons, for example, where you take something but twist it in a certain sort of way. But anyway, there's just to say those things. So, Robert, I just wonder what did you make of it, and what are your thoughts also on how things have developed since that article, that the text was submitted, and since it was published? Yeah.
So I think one way to kind of take a big step back and figure out what we're even talking about is to say, well, what's like the fundamental purpose of copyright? And I think one answer to that is to say that copyright exists to foster the arts. And the reason we are willing as a society to give an artist a monopoly on their work is because we figure that that's going to encourage them to produce more work, to produce more work like it, things like that. So then in the context of generative AI and art, we have two kind of groups of artists, right? We have all the traditional artists that put their images on the internet and whose work is being scraped. And then you have another group of artists, and maybe it's controversial to call them that, but I think there's some real artists there. Another group of artists that are using these tools to generate new forms of creative expression. And it feels like there's a little bit of a balance between these two groups of artists. Now, I think that is maybe overly reductive or naive, because the decisions that we make with regard to generative art are likely also going to be relevant in the context of AI for producing, computer code, AI for producing text. And so there could be really far-reaching and very high dollar effects based on the decisions that are made with regard to fair use in the kind of generative AI art space. I totally agree that it's hard to prophesy what's going to happen. And it seems like, in this context, US law is a good place to start, simply because so many of the lawsuits are happening here. I will say that I would be surprised if we saw a decision that made it impossible to have generative AI. And we could imagine such decisions, right? We could imagine a decision that resulted in something along the lines of you would have to bilaterally license with each and every artist in the training data and come to an agreement there. That strikes me as not being practical. And again, right, if this happens in art, it could also happen in computer programming code. It could also happen in just raw text. And I think for many folks that seems like a fair outcome, and I'm not disagreeing with that. I just kind of think it's unlikely that we would see a decision like that. So that leaves us with some version of fair use, but there's still kind of a big sliding scale. And specifically, and this the article kind of addresses a little bit, you could say, look, it's okay to take images from the web, to put them into a database and to train an AI on them. That part is fair use. And updating the model weights through, this training process, all of that is fair use. The moment you start creating outputs, however, there's a whole separate discussion And any one individual output might violate the rights of someone in the training data. And so we say, look, it's fair use to train the model, but that doesn't mean that all of the outputs are automatically non-infringing. That seems like it could be like a way that, you know, we resolve this. Again, it's really hard to know. But you know, that's one direction. There are also kind of creative licensing schemes that people have considered. So there's this idea of a compulsory license, which we mentioned in the article very briefly. And the idea there is to say, look, an artist doesn't have to like explicitly give consent. Like you can just use their art to train an AI model, but when you do so, you have to give them some kind of minimal amount of licensing fees, and that's kind of preordained what that's going to be. Unclear. I mean, to Jessica's point, you know, it would be cents or maybe fractions of cents, and whether that actually makes a difference to any of these artists is kind of a big question. And I think it's interesting, and it makes a lot of sense that we go beyond just like the narrow copyright discussion to think about how to compensate artists, how to continue to encourage creative expression, which kind of is the fundamental goal here. Neil, you asked me what has been happening since, and I think one of the things that has been happening since that's kind of interesting and that I've been working on is we're seeing the rise of data sets that are not purely kind of scraped from the internet, what people would sometimes call unsupervised data sets. But instead, we're seeing the rise of supervised data sets where people actually spend a great deal of time and effort annotating the data. This is mostly happening in text. So a lot of the kind of most recent improvements we've seen in ChatGPT and you know, those kind of text models, large language models, has been driven by these supervised data sets. And the legal status of those data sets is also really kind of poorly understood. And the kind of interesting distinction between those data sets and the art that we're talking about here is that those data sets were created for the sole purpose of training AI, right? Whereas, you know, the art was not created for the purpose of training AI. It was created for various other purposes. But you could imagine that you have kind of and we already do have a market for data that's kind of curated for the sole purpose of training AI. Separate legal considerations could apply to those. And we've been kind of trying to get an understanding of what does the landscape of these data sets look like. There's a few thousand that are commonly used. We've annotated the kind of different license agreements. It turns out that a lot of the data is annotated using other AI, so like data that's annotated with OpenAI, things like that. So there's some really interesting kind of complexities. And I'll finish by saying, you know, we probably need to find solutions to them right now, because it's going to be very hard to wait for courts to make decisions. And this is, you know, a space that's moving at a million miles a minute. And so we don't really have the luxury of waiting until 2025 or 6 or 7 or whenever we have kind of a definitive or something definitive-ish from courts. So yeah, really interesting space.
Yeah, thanks, Will. Just, a couple of comments. I mean, firstly, in terms of supervised data set, that's actually what's happening in the field of architecture. Not for that same reason. It's rather these kind of generic large language models, which are trained on, you know, vast array, are not especially good for a particular domain such as architecture. So we're now finding that, for example, there's a company, actually we've been with us yesterday, LookX, which is a AI developers for software for architects, and set up by someone called Wan Yu He, who used to work for Rem Koolhaas, hence the name XCool, and they're deliberately training it on buildings, and they have meticulously been labeling this work for some time in China. And of course, there's slightly different copyright laws anyway in China, which is just simply so you get something that's maybe more customizable. I mean, the moment what we we find, for example, is if you use Midjourney or DALL-E, unless you're going to find an architect who is got a very unusual name and has got a high media presence, someone like Zaha Hadid, then if you've got someone called John Smith, you're unlikely to be able to refer to that particular architect, such a common name. So the need for supervised data sets is coming in, and also another practice called Hilblau, for which Daniel Bolajan, who's also been part of Digital Futures on many occasions, has been the kind of lead AI architect, expert, as it were. They are doing it internally within their office, and meticulously labeling their data with a very carefully controlled set of labels in order to basically use that over 1,000 projects to possibly produce something new in the future. So there's already been that sort of people are working at that at the moment, but there was one particular question. I think the question is that really is whether we understand all this. I mean, it seems to be the crucial, the heart of all things. And I think what's been so great about today's session and your contributions, Robert, and also Jessica's, is that really that we don't understand what's going on. There are lots of kind of like questions to be asked, and I think frankly fundamental misunderstandings. I think basically the misunderstanding of copyright law, that somehow you can just sue someone and it's straightforward and you'll be successful and so on. That there's a lot of the naivety that shall we say there among non-lawyers. But then I want to suggest, and I want to just offer an example here to show that even in the legal community, I think there is a certain confusion. Before I do, I just want to mention briefly, we're going to open up to questions from the audience fairly soon. So if you've got any questions, please put them in the chat. But let me just quickly share my screen again, just to go and point out one particular issue, which I personally think that the law has got wrong, but maybe I'd like to hear what you think. This is a case, and this is of course, one of the kind of crucial issues. And this is a ruling, a fairly recent ruling, that the US judge rules AI generated art is not protected by copyright law. And the key point is, and unfortunately I couldn't show everything on this screenshot, but the word missing at the bottom is human involvement. A federal judge in Washington, D.C. ruled on Friday that artwork generated by artificial intelligence is not eligible for copyright protection because it lacks human involvement. Now, by contrast, I would want to cite the example of one of the leaders in the field of AI generated art, Mario Klingman, who was the winner of the Lumen Prize, and we have someone from the Lumen organization with us today. And I think this is absolutely right. This is Mario Klingman, who has been using GANs to generate models. This is his comment. If you heard someone playing the piano, would you ask, is the piano the artist? No. So the same thing here, just because it is a complicated mechanism, it doesn't change the rules. The typewriter enables someone to write a book. Well, for me, the keyboard enables me to write code. And then, well, yes, there are neural networks involved, but maybe you could say that they are my brushes that I learned to use. And I guess what I would say alongside that is, in some senses, that what seems to be the key issue. I mean, in some senses, this is an example of technological determinism. In other words, say that this is either this or that. Whereas I think it's a much more nuanced question, and you can't categorically blame the technology, shall we say. So, I mean, for example, I think that in the end, the key question is, it's a tool. That's, to my mind, it is a tool. And a tool has certain affordances, and you can do certain things with tools. With a kitchen knife, for example, this is an example I always give, so forgive me for repeating myself, but you can use a kitchen knife to chop up your vegetables, but you can also use a kitchen knife to murder someone. But so far, no kitchen knife has ever been convicted of a crime. And I think this is the important thing when it comes to these tools that people often overlook, is really who is in charge and who is doing what. So instead of this idea that somehow also surveillance, let's say, is necessarily bad, it's a question of what use it's being put to. I mean, I think that facial recognition is used in opening up your phone, and nobody's going to complain about that. And certainly we know from the UK that the famous case of Jenny Bolger, where a young kid was abducted by a toddler, was abducted by two young kids and murdered. And they only found out about this because of the CCTV camera outside the mother care shop in the UK, and hence, CCTV cameras have a positive role, and so on and so on. I think the idea that somehow you blame the tool is wrong. It's actually the person using the tool. And the other example I would cite was that here in LA, when I'm based right now, there was a case recently when somebody was one startup. They had a copywriter who was producing text for advertisements or whatever, and they sacked her because they found out that ChatGPT could do the job better without spelling mistakes and also much cheaper. So the question is, was it the tool? But did AI sack her? Of course not. It was the financial officer or CEO of the company that sacked her. And I think this is an important thing to realize. It is the human agent when you're dealing with these tools. At least this is my position, and I don't know whether that's correct or not, but I certainly would call into question that judgment. So Robert, I'm intrigued. What would you make of that? Am I completely off being?
No, I agree. I think that there's a host of issues that come out of giving these tools too much and doing too much anthropomorphization and casting these tools as these independent agents. I think for the time being they are tools. Maybe one day we will live in a reality where they are more than tools, but that's not really where we're at, as far as I can tell. And so the case that you mentioned in the DC case, there the plaintiff kind of insisted there was no human involvement, and so forced the court to narrowly decide on the issue. If there was a work of art that was created with no human involvement at all, is that copyrightable? And the answer is no. And I think that, at least basically based on current laws, that's correct. The question that I have, and kind of the pushback that I have, is I don't think that it's correct to say that these tools are creating outputs in absence of human involvement. I think there's a tremendous amount of human involvement by a tremendous number of different kind of agents, human agents that contribute creatively, right? From you have the developers that are designing the tools in certain ways, to the output artists, or the people who are prompting the tools to generate the outputs they want. Jason Allen, the person who won the Colorado State Fair a number of years ago with a generative work of art, went through several hundreds of iterations back and forth, and kind of modified the output, really thought carefully about it. And the same is true kind of a camera, right? Like, there is a way that I could set up a camera and take a random shot of something, there's no human involvement. I just took a random shot. We'd have to think a little bit about how you went about that, but you could imagine something like that. And then I guess there's no human involvement and no copyright protection. There was a similar case like this, actually, where a camera was stolen by a monkey, and the monkey took a selfie, and same outcome, right? No copyright protection because the monkey can't own it. So yeah, I think the court did nothing wrong in this case, because the plaintiff kind of forced the court into a certain position. That being said, I do think that what the law sometimes gets wrong is it focuses on kind of technical aspects that are not critical necessarily. So one example is you'll frequently get this argument along the lines of, well, whether or not there's copying and copyright infringement, right at the beginning when you create your training data set, you're making a copy of the individual works of art. And it is that act of copying that gives rise to the copyright infringement. And one, maybe we could come up with a technical workaround for that copying, right? There's all these kind of multi-party computation approaches where you're not making copies, but kind of more importantly, like, that's not the part that we're worried about, right? And I would urge kind of the legal minds that are thinking about this really to like, let's hone in on the part that we're worried about, lest we like make up rules based on some kind of minor component that can easily be subbed out, and then we're back to square one. So I worry about that a little bit. Anyway, I'm excited for the questions.
Right, I'm muted. Can I just pick up on one thing you mentioned? You said you don't think that generative AI is going to be outlawed. I mean, why? What is the? I mean, maybe you could just unpack that slightly. I mean,
yeah. So I think that's it's not an obvious conclusion to come to. I think that the amount of potential value, it seems that generative AI, and again, broader than just for art, right? But for computer programming, for generating text, for all sorts of things, the potential value that it can bring seems quite large. And the idea that we would completely close the door, come up with a copyright decision that just completely closes the door on it, seems unlikely to me. If for no other reason, then this is a very multi-jurisdictional kind of technology, right? And while the litigation right now is happening in the United States because the companies happen to be in the United States, that is not necessarily a reality we have to live in, right? And so all you would really need is one jurisdiction that was very friendly, and we would all kind of come down to the lowest common denominator. And then, we saw this very briefly with Italy that outlawed ChatGPT over privacy concerns. And like it lasted a few weeks, and then people, kind of said, no, we want this. We want ability to use this. So I think it just doesn't strike me as realistic that we would kind of put the cat back in the bag, put the genie back in the bottle. Yeah, maybe, time will tell. But that's kind of my perspective. And based on that perspective, I then think, okay, if we're going to have this technology, how do we maintain the technology in a way that is fair, that continues to, encourage artists to, express themselves and come up with new things, and that ensures that if the tools do replace folks, kind of the labor economics angle, that we don't continue to drive kind of inequalities and things like that. But all kind of based on the premise that the tools are here to stay and are likely only to get better. Yeah.
maybe I could. We got a couple of questions in the chat which I want to go on to in a second. But just one follow-up question, which is to say the question of it, well, how do you enforce something where you're operating online? By which I mean that we already have problems anyway. I mean, the International Court of Human Rights has difficulty in exercising its authority, shall we say. You can make a ruling, but how do you enforce that ruling? How do you stop Putin, invading Ukraine? That's one thing. But then it becomes muddy when you're dealing with something that is kind of online. I mean, where does the responsibility for online material lie? I mean, is it if Google's headquartered in the States, then does that mean it comes under the state's jurisdiction? Presumably yes, from what Jessica's saying. But how does it work when it's kind of not so clear where someone is based? I mean, for example, even a digital futures organization, we have no particular base. We're online. We haven't, or we're about to become a non-profit registered in the States. So maybe that is going to be the case. But I think there are many situations where it's not clear under which jurisdiction this would come. Do you want to comment on that?
Yeah. So you have the issue that it's not clear under which jurisdiction it comes, and we have complex rules of kind of civil procedure to figure out where you can get jurisdiction over defendants. But two, you have situations where it's fairly easy to make it come under a certain jurisdiction, right? And it's not inconceivable that one jurisdiction would kind of emerge as being very friendly to generative AI and to say, look, we welcome the tax revenue, and we are a hub for innovation. Come here, we have friendly laws. And like, this is not the first time we've seen something like this. Only here, it wouldn't be very costly, right, to kind of move operations. And then you have a question, right? Like then you could have situations where some jurisdictions ban generative AI because, you know, they don't trust the kind of legal analysis. They don't think it's fair. They, you know, you could imagine that you have kind of like different versions. We already see for text, you know, siloed versions of AI that were trained only on kind of public domain text. And so you could imagine, you know, like a GDPR compliant European, you know, AI version, and then like the US version, and then the like, you know, international, like anything goes version. Yeah, I mean, that's impossible to predict, but and all of this is kind of irrelevant to the judges making the decisions too, right? At least it shouldn't be top of mind. But I have a hard time believing that we will create a set of decisions that would shut down the generative AI industry in the United States. Yeah. I think you're muted, Neil.
Yeah, my apologies. One very small follow-up question. Just because it relates to the work of Xcool, that was, so the material was actually it wasn't scraped from the internet, but let's say it had been scraped from the internet, and it was done in China. Now, then the tool is being used elsewhere. Does it matter where the infringement took place, or, you know, is it as soon as there's been an infringement under international, seen in international context, which becomes where, how do we judge those things?
So it gets complicated, and you're testing me on my Civ Pro, but essentially, I think one thing that matters is like where are the entities located, right? So if the infringement is done by a U.S. entity that, you know, is located in the U.S., all of its employees are in the U.S., everything is in the United States, but, you know, this one act of infringement is done elsewhere, I think that would be ineffective, and likely a plaintiff would be able to find a court in the United States to get jurisdiction over this entity. The other question, though, is like, what is the act of infringement, right? So say we decide that creating a generative AI model based off of scraped images from the web, that's fair use. However, certain outputs, you know, if I say, okay, well, generate an image in the style of this artist, and I'm really kind of trying to copy, well, that might be an instance of infringement, right? And there it might be the case that it is not necessarily the developers of the platform, but rather the user that is trying to use the platform to infringe, that faces liability. And so in that case, it might be the case that, you know, the liability, the jurisdiction would only extend to like the location of that specific user. And then there's a question kind of more broadly about what are the responsibilities of the developers to make sure that they're creating tools that can't be used in these ways, right? Which is really complicated when you realize that copyright is subjective. So we've had lots of kind of computer scientists who said, well, we can just train a model to detect, you know, infringement. And then at the, you know, the last layer of our generative AI engine is going to be a infringement detection engine. And that's going to make sure that we don't generate any infringing content. But that's easier said than done. And there's kind of a subjective analysis. So yeah, some thoughts. I don't know if that answered the question.
No, it does. But just, okay, one small part, just because I'm interested in the particular case of Xcool, because I think in China they're fairly safe anyway. But the point is, they just opened up a branch. They flipped the name around from Xcool to be LookX, and they opened a branch in the States now. So the material was generated in China, but they now have a US company. Does that make any difference?
I think one would need to know more. For a specific case like that, it depends on minimum contacts and all sorts of additional factors. So one would need to know more about the specific situation. Yeah.
Let me bring in Robin. Sorry, I've hogged the conversation so much. Thanks, Rob. This has been absolutely amazing. I really enjoyed this. Lorena has a suggestion. Lorena is actually in Miami. Lorena, please.
Yes, thank you, Robert, so much for all of these insights. It's really interesting because, I mean, for me in particular as well, because my background is that I work at Gensler, which is, you know, the largest design firm in the world. And, you know, these conversations are so critical all the time as we're trying to figure out how we navigate in this space. So I was curious, in this element of human involvement, and if there was any thought that's out there right now in terms of quantifying or developing a sort of percentage of the amount of human input in these various mediums. Because, for example, when you see the connection between Midjourney to images, you could input 2 words, which are a text form, then it generates an image, which that's a huge leap in almost scale and dimension and in terms of input. But then there's other kinds of models where perhaps even if you put an entire rough draft of an essay or a book or something, and then it finesses that's obviously a lot more human involvement. And it's particularly of interest of architects, I believe, because there are different things out there like the LookX, like spatial diffusion, where you input a sketch, which is an image, and then it's developing off of that image. So just wanted to hear your thoughts on that.
Yeah, so right now, the decisions that have come out feel kind of a little bit too broad. So I'm thinking specifically, there was a decision by the US Copyright Office, and it kind of made this blanket statement where they said, things generated by generative AI are not copyrightable because they're not made by a human. And that, in my view, is a bit of a break in precedent, because usually we've had a very, very minimal definition of kind of creative involvement, right? And the reason for that is fairly obvious. Like, you don't want courts making decisions on whether, a red square painted on a canvas is sufficiently creative or not. Like, we just don't want to go there. So we kind of say, look, like if somebody thought about it in any way, shape, or form, and that somebody was like human, fine, right? Which also means, like, if I decide to take a single random photograph in the next 10 years, I set up a camera and like it takes a photo, like that's probably enough. It really is like a very low bar. And so by that logic, it appears that as long as you are somehow involved in providing the material something, it should meet the threshold. But yeah, that's open. I will say, so say you supplied a sketch, and then obviously you would have copyright in that sketch, and then the AI comes back with kind of a more fully fledged like design. It would only be kind of, and this is like the hard thing to conceptualize, somehow it's like the delta between, like the difference between the sketch and the full design is what's like not copyrightable, but like the sketch obviously is. So it would create, in my opinion, kind of a bizarre world to live in if we didn't allow for the outputs to be copyrightable. So yeah, I expect that we will see a little bit of reversal, but like, who am I? So yeah.
Understood. It's definitely a challenge. Thank you.
So we've got a couple of questions I want to ask. First of all, Angelica, and then Vasco. We're spanning the world today. Angelica is in Sao Paulo in Brazil, and Vasco is in Dhaka in Bangladesh. So Angelica, please.
Hi, Neil. Thank you. I'm actually in Porto Alegre, not in Sao Paulo. I live further down south. So I have a couple of questions. First, how far we have something like we're calling human agency. So if I produce an image with a prompt, and then I start dealing with the image, and then doing in painting, out painting, changing the image, taking to Photoshop. Now Photoshop has a tool that you can change and stretch, and then I start working with it like a sort of collage. Could that be considered? It came from a prompt, and the first output was from the machine, but then I start working with it. Is that output, workable output, could be considered like copyrightable? And the other thing is about architecture, because we are talking about drawings and images, but architecture is about building and construction. So, and we have to deal with things like local codes and topography and climate and everything. So it's very hard, I think, in architecture to say that you're copying exactly the work of somebody else, because in the real world, if you're going to build it, like it's always going to be different. So how far that could be considered an infringement with the construction, or even with the drawing, if I'm going to use the drawing for what? For just to display as a picture? that's my two things that I was thinking about. So if you could comment.
Yeah, so on the first one, I think, again, case by case and all sorts of additional considerations, but it seems like that you're adding so much human involvement when you're doing these kinds of things that feels similar to, look, if I made a sculpture out of newspapers. Well, like, yeah, they're newspapers and like somebody else holds the copyright or, whatever, but like I'm creating something completely new and a completely new like arrangement. So that seems like a fairly easy case. And the question is just like how much additional work do you have to do?
We also do work a lot of in style of, sort of, when you teach students, they have to use references. And this is part of our daily work. We use references. We learn how this particular architect or artist is working, and we try to capture that into our own work. And that's the world functions like that. We don't create anything from something from anything. You have to start a starting point. How different is it if you use a machine to help you do that, or if you use your own mind to do that? Because our mind is full of these images, and we start drawing it. We may capture things that we don't even might remember where it come from. And sorry, that's another bracket that just.
Well, so like, yes, I agree. All human creative expression doesn't happen in a vacuum, is informed by our experiences and the art we've seen. Definitely true. In each individual output, like, there is a question, does it resemble a specific work that already exists? And it's not really, especially with generative AI, where we assume that it's seen all the art. So you can't really say, oh, look, I've never seen this, work of art, so I kind of got there by myself. So yeah, there is a question, like, if you're creating something that resembles somebody else's work too closely, and where that line is super subjective and complex. But
you might even not even know where it, if it's machine generated, you might even not even know that it was something related to something. You don't know where it comes from. You don't have all the image that the machine has. So you might, like, with the company, you're gonna be induced to use something that might resemble to something else that you don't even know about it. You have to put it on Google search image to see if this is related to something. And even so, it's not exactly the same. And then that comes to my final question: how far do we go in architecture to that? Because architecture is different than art, right?
Yeah, I mean, in architecture, it's interesting. And I'm not an expert on intellectual property in architecture, so I might be the wrong person to ask, but my sense would be, to your point, right? Like, there is a lot of similarity in, like, maybe the designs, but then once you actualize them in real life, they look very different. So I would expect maybe it would be less of a concern in architecture, because even if there's the same starting point, the kind of endpoints would be so different. But I don't know. I don't know. I mean, there's also, like, questions about, like, say you could imagine that you create an output that is very similar to a prior existing work of art, and that wouldn't be a problem, like an infringing creation, if you sold it for money, but it wouldn't be if you used it to teach a class, for example, or if you used it for research, or if you used it, like, as part of your creative process. So it also, like, depends then not only on what you're creating, but also how you're using it. So it gets really quite complicated, but yeah, hopefully that was helpful.
Yeah, it's case by case, right? So we're, like,
case by case,
walking on eggs, as we say here. Okay, thank you.
Exactly. Thank you for the question.
Just maybe I could follow up that there are two interesting comments that come out of that. I mean, well, firstly, there's a building and someone photographs the building. So that already is kind of, you're taking someone else's image, so the photographer is almost not innocent in some sense. And architects do work in the realm of representation. They don't do the building; they do the representation of it. But it seems to suggest that possibly the copyright issue would be if you took someone's photograph of that building. But that leaves me kind of a little disturbed anyway, because the photographer has taken the building itself. That was, that's a bit, I don't know if that makes any sense at all. Okay, so we have another question from Vasco, who is in Bangladesh. And Vasco, is it noisy there? Can you put your sound on and ask your question, or I can read? Okay, it's always noisy in Bangladesh. I know that from having visited Bangladesh. So let me read out Vasco's question. Are there any emerging technologies or solutions, such as blockchain or AI-generated content registries, that hold promise in resolving issues of attribution and compensation in generative AI? Sorry, let me read that again. Are there any emerging technologies or solutions, such as blockchain or AI-generated content registries, that hold promise in resolving issues of attribution and compensation in generative AI? I think it's a great question, personally. Robert.
Yeah, I mean, there's tons, and like we could spend 2 hours talking about them. One proposal that you see a lot is something along the lines of, well, you know, we can figure out who all the authors are that went into the training data, and then we'll compensate them via, you know, some blockchain system, and that will reduce the cost of the compensation. And while it's true, like it makes it easier, and you could imagine kind of a technical system that makes it easier to compensate the artists, which is often cited, right? People will say, well, you know, it's impossible to figure out who all these artists are. And so we could never compensate them. It doesn't change the fact that either the compensation is so high as to make it impossible for generative AI to proceed, or it's sufficiently low to not be an issue. But when you have literally hundreds of thousands, millions of individuals who've contributed, they're all going to get pennies, right? And the issue, you know, this is what Jessica highlighted. It's like, even if we compensate people, it might be not very much for any one artist, not enough to make a living. We already see this with Spotify. And so that doesn't really solve the kind of the hard question, which is, how do we continue to incentivize human creative expression? So that's one. The other one that I mentioned is, can we train an AI to not produce infringing material, right? And that gets raised all the time. But the challenge is that the legal analysis is fairly subjective, and so it's hard to build technologies that are sufficiently kind of nuanced to capture that. Although you could imagine that you build something that just notifies the person who's prompting the AI tool, like, hey, there's some very similar material out there. Like, do you want to take a look? And kind of places the onus on the human, but helps them make that decision. Yeah, and then there's many more kind of emerging technologies, but I just thought I'd talk about those too.
Just maybe I could comment I meant to make about the previous question, just to say that, you know, certainly as part of where the user is concerned, there's always some kind of iterative process, in the sense you're not dealing with something. Just from a very basic straightforward point of view, when you generate something using Midjourney or DALL-E, it gives you 4 options. So you've actually got to choose. So there's already some process of iteration, which means it's kind of already in process. It's not a kind of unadulterated image just taken from AI. We have a question here from Deepti. Deepti is originally from India. She's currently in France, and just shows how international we are today. Deepti.
Hi, thank you so much for this conversation. It's been very interesting, particularly because I've just recently been working with my employers on copywriting some of their work, and they work with textile, and I know that it's really expensive to copyright, because each country you want to copyright something or trademark something, and there's so many different definitions. So personally, even though I'm not an expert in legalities of copyright, I wouldn't think copywriting is a solution, or copywriting is a sort of a place to go for artists or creative people when it comes to this new tool. Having said that, I'm curious, what are the other legal frontiers for generative AI, where the challenge is coming to the courts? Is it only with copyright, or are there like other places where people are beginning to challenge generative AI outcomes. And this I'm thinking particularly because considering that these large language models are produced and maintained by technological monopolies. So are there things coming up from the front of unfair competition or, because it is a serious David versus Goliath or even worse so kind of situation, like you cannot fight this, right? That's my question.
Totally. So there are certainly other kind of legal dimensions to this. Some are kind of basic, like, what kind of terms of use can these companies enforce and things like that. But I think the more interesting ones are privacy, right? Like what happens when details about my person are surfaced to users. And there you have both. I've seen both. I've seen people saying, look, it's privacy infringing when it knows my birthday, right? When you can ask what is Robert Mahari's birthday and it knows. I've seen other lawsuits that are talking about defamation, where you put in somebody's name and they say, oh, this is an international criminal. It's not true. And people get quite upset about that. So, and I know for a fact that there's lawsuits about defamation. Then you have questions about decisions, right? So what happens when, maybe it's ill-advised, but a hiring manager uploads a couple resumes to ChatGPT and says, hey, which of these people should I hire? And then, somebody gets hired and the rest get rejected. So like, or other kind of decisions that are happening in the real world, right? And there might be like economic ramifications for those. That's another kind of set of questions. And by the way, so like in the EU, the GDPR provides certain rights with respect to kind of automated decisions. And then finally, and I think that's an interesting one, is the question of antitrust, monopoly, things like that. And you're totally right. It's kind of the usual suspects, right? Microsoft is pioneering here with OpenAI. You have Google's Bard. You have a couple of independent AI companies, but it's fairly concentrated. The one thing I'll say, I expect that there will be antitrust questions, but one of the proposals that comes up a lot is to say, well, we want, and I think one of the questions mentioned it, we should label AI generated content as such, right? We should have this requirement, like a watermark or something. And I'm skeptical about whether that would be, feasible technologically, but it's also much harder to enforce such a thing when you could have anybody creating, and hosting generative AI engines, right? And so there's a question about whether for this technology, like if we want to treat it as kind of a high risk technology and only have kind of certain entities have access to it, or at least certain entities have like full unfettered ability to modify and champion this technology, or whether we want it to be kind of more of a consumer technology where we say, okay, the more competition, the better. Everybody should have this. And, to some degree, this is not a decision that is going to be made by the courts. It's going to be made by technology itself and business and stuff like that. But just a thought on the antitrust issue.
Yeah, but the interesting thing is obviously the challenge is going to come to the courts, right? Where,
Yes.
the battle is going to happen, at least in America, where where there's a culture of going to court for this. In India, for example, there are no copyrights, like you cannot really, like the Indian pharmaceutical industry really thrives on that idea, right? Like it's difficult to copyright or protect something. So, which is why copywriting in a global perspective, it's not really something that outside of OECD countries, you don't think about it, right? It's not the pathway you take. So that's why I was curious. But thank you for this.
Thanks for the question.
Marcelo, would you like to ask your question? Marcelo, originally from Venezuela, currently also in Miami. Yeah.
Hi. Hi, Robert. Thank you so much for being here and to talk about this controversial subject. So I'm gonna read straight from my question. So quoting Picasso's famous quote, right? Like good artists copy, great artists steal. To me, the message behind this is poor artists copy, great artists transform, right? So meaning that a good artist appropriates something just to generate something new, while a poor artist or mediocre artist will just wants to aspire to become their favorite artist, right? So that being said, can a line be drawn, one that can help to discern when a work of art has been copied versus when a work of art has only influenced another? Yeah. So
I think I'll say two things. I think, first of all, very hard, right? Without the context, without knowing, what was the relationship between the two artists? Like maybe one apprenticed for the other, and so the works look so similar, but actually it's after 10 years of learning from, the master, the student becoming the master, things like that. Who knows? So, purely two pieces of art side by side, was this one copied from this one? It's hard, right? It's hard from like the artistic perspective. It's also hard from the legal perspective. The other thing is to realize like, what is the value of these tools? I think some of the values really, look, we can generate new, incredible, sophisticated, high-end art. Part of the value, maybe the bigger part, is to say we can quickly generate things that are pretty good, right? I can quickly have a design for my brochure. I can quickly have some like images for my website, whatever it is. And so they're like, do people care whether they're imitating versus, transforming? I don't know. I doubt it. They care insofar as they don't want to be, liable of infringing someone's copyright. But like beyond that, I don't know if they care. And so it's difficult, right? Because like we want to hold ourselves to these very high standards, but it's hard to do in practice. Yeah.
Thank you.
Of course, thank you.
So we have a question from Yi, who's in a library in Milan, I believe. Yi is originally from Shenzhen in China. And because the library is a bit noisy, I'm going to read out her question for her. Yes. If AI systems can iteratively generate thousands of valid architectural proposals, does that diminish the value of the individual creative architect? How might this disrupt hiring practices? How will firms and individual architects adapt their business models and services given advancements in AI design capabilities? Is the question in the chat? In the chat, yeah.
Yeah, this is, I feel like almost every profession is asking itself this, both from like what makes us excellent perspective, like how do we make sure that we have creative contribution and we're excellent at the height of our field, and if this machine can just produce what I've been making and spending my whole career learning how to make, like where does that leave me? And from the pragmatic, well, geez, like how do we keep making money if people can churn out these designs? In my own work, I work a lot with law firms and thinking about how these tools affect the practice of law itself, right? Like you can now generate a contract or analyze a contract. Do you really need to spend, thousands of dollars on your high-end lawyer? And so, yeah, this is a very universal question. I don't think we have good answers yet. My hope is, and what I think could be effective, is to use these tools to extend the human architect, the human lawyer, the human designer, whatever it is, right? So like suddenly we live in a world where you can take a sketch and turn it into something that's much more fleshed out, and it takes 20 seconds. You can generate a bunch of different sketches to kind of inspire you to solve the blank page problem. You can do all sorts of interesting things that maybe can help improve the creative process. And I think we're still fairly far away from, like no one's designing like the entire building and then like sending that to a general contractor and saying, go build it. Like there's still many steps, and there's still so much room for experience and knowing what kind of designs work, and understanding all sorts of like the intricacies and the science and the technology and the engineering, and like there's so much more to it than just like the design. And even if it were just the design, it's not like these engines are good at designing things. Like I've seen lots of examples where they design things like structures that are kind of physically impossible and things like that. So I think there's still lots of room, but like I said, during the first hour, like it feels like the tools are here to stay, and it behooves us in all our different professions to understand how we can learn to leverage those tools to extend us.
You say thank you. I wanted to just quickly pick up on one thing but years ago when I was working up at an office, and I had some friends who were academics at University of Cambridge in law, and we had in the office we had a legal question, and the academic colleague was saying, well, actually, what happens in a law firm? If you want to kind of overcome the problem of copyright, you take someone and put them in a room with a bit of paper and a pencil kind of thing, and say to them, without any direct influence from anyone else, just sketch out for me what your idea is. And so you can establish there's no direct connection, no direct copying, which I thought was interesting as a strategy. And I'm just wondering, I mean, in the context of that early example I gave you, I don't know if you know this pavilion in Barcelona, Mies van Rohe's Barcelona pavilion. It was, I think, 1930s or something. It was erected and it was taken down, and they reconstructed it. And of course, you get many reconstructions of buildings and different things. But the argument was they weren't copying the building; they were re-articulating the design, which in some extent is the idea about the building. Does that complexify things if you think about architectural designs as an idea?
So I really should underscore that I don't know all that much about how intellectual property protection works in the context of architecture. So I'm not sure. I mean, I guess like we can go back to like the first principles, right? So what do we want to do? We want to kind of encourage architects to continue to make interesting, beautiful structures. How do we achieve that? We give the architect some limited kind of monopoly to their design. Now, the difference with architecture is like, once you've built the building, well, that's a pretty nice kind of flag to have, right? Like now you can say, look, this is my building. And someone else comes along and draws the building, meticulously draws the building room by room. They haven't copied the building. They've created something else, but like it's not quite the same thing. So I guess it begs the question, do we need, and do we have, and I don't know the answer to that, the same kind of copyright protections in architecture as we do for like, say, painting. And then the question of kind of re-articulation is, you just want to figure out like, how do we, on the one hand, give people enough room, like this monopoly on your work should be broad enough that it is sensible, right? So that if someone changes a single pixel or, like makes a door 10 centimeters shorter, that doesn't completely invalidate the intellectual property. On the other hand, we don't want it so broad as to exclude others who might have interesting kind of alternative takes and be inspired. And so I think, again, it's a bit of a case-by-case determination. I don't know how it's handled with architecture. But I guess what really makes architecture different from the creative industries that we typically think of as being endangered by AI is that there's like a very clear big set of steps that happen after the initial sketch, like after the thing that the AI could feasibly do. There's so much more. So yeah, I think architects are probably, I don't know, in a good position.
Well, I think, actually, in general terms, my book Camouflage was about mimicry, mimesis, and things to do with that. And they often say that AI doesn't copy, humans copy, but human copying is so imperfect. It becomes a creative reinterpretation. You're never going to replicate exactly what is there. So it's a little bit different to the case when you might replicate a digital image, which literally can be perfectly recreated, as it were.
Right. Although it may not, I mean, we've had cases where people are debating parts of songs and things like that. Like, it doesn't have to be a perfect copy to rise to the level of infringement.
So we've got a couple more questions, and Gustavo has been putting some comments in the chat. I don't think, Gustavo, would you like to ask your question? There are a whole series of different interventions. Welcome, Gustavo. Gustavo is, let's say, in Santa Barbara. He's a postdoc at UC Santa Barbara. Gustavo.
Yes, hello, Robert. Thank you very much for the wonderful summary and really describing kind of the extent of the problem. I think what I wanted to do was maybe kind of open up the idea or the concept behind property and intellectual property. I thought about the idea of when these historians look at infrastructure, let's say, a highway is a technology that that actually builds wealth for the greater good. And it seems as though that's kind of conceptually the argument with AI. It's actually a greater good technology, but it does displace the homes, the property underneath, the people that have been displaced. And at some level, there's a history of redlining, and there's a history of these highways going through people that did not have the power to take this away, right? And to me, that metaphor kind of reads clearly here. Just because you have the power to do something doesn't mean it's legally right. So we're kind of setting it back. I think my question is, if the bottom line is that, you know, property was stolen to use to make these tools at a base level, and there is a mechanism for compensation, why is there, how can we, I think, update or redefine the compensation beyond what's going on with the pennies? Because what I do know is, I think the Sackler family was a really good example. When they were litigated, even the billions of dollars that they were litigated, it was still interest that they still could have had generational wealth, right? So if we want to make a judgment that continues to help the company but feeds the people, why would that be a tax burden for the US consumer to give kind of a minimum wage for an artist instead of the companies that actually are making a profit? And let's say OpenAI lasts for 10 years. That's billions or trillions of dollars that they're going to gain. Why can't there be a percentage outright for the artist? Is that something that you've looked into as a possible scenario? Or would that be like an economist or some sort of like a computer science legal scholar to kind of detach?
Yeah, so I'll answer the last little bit. It's not something that I've worked on myself. So, you know, the first question is like, has property been stolen, right? And there's like a narrow legalistic question here, like, is this fair use? Is it not fair use? But I think actually, and correct me if you don't think that that's the point, like that I'm correct, but I don't think that's the point, right? Like the point isn't like whether we can come up with a justification for the use of this work. It's more about, look, without these artists, we wouldn't have this technology, right? It's true. Like there's no way around it. And so like, obviously the technology owes something to these artists. By the way, art is a social good as well, and we should encourage it. And so we should, you know, make sure that artists can make a livelihood, right? And that almost has nothing to do with copyright. It's just like, because that's the right thing to do, because we want to live in that world. And I think that's kind of the point that Jessica was making in her contribution, that look, it's not like a copyright solution, but like, what if we had more government support for artists? Like maybe that's kind of the solution here. I think that makes a lot of sense, right? There's, you know, with these pennies and cents, it's just like a question of like, who pays, right? And if it's, you know, the AI companies, they're wealthy, but they're not that wealthy, right? They're extremely wealthy, but they're not able to support by themselves the entire artistic industry and you know, all the artists that are out there. Governments maybe are in a better position to do that, right? And so you could imagine that kind of a government support system could be more feasible. Yeah, and then I do think that there are going to be differences between the different types of copyrighted material. And, programming code that's on Stack Overflow that was scraped to generate, models that can create, code is quite different in many ways from, images from Getty Images, just in terms of like what its purpose is, how it's competing with the original, all sorts of kind of additional questions. So I think we'll see maybe a range of different decisions on these different kind of types of material.
Yeah, I think to just maybe go back to the idea of kind of the use or the purpose. I kind of see it as a cop-out when we go back to, oh yeah, the government's going to support artists, because quite frankly, we support the corporations with their low tax rate. So I think that to me is kind of this non-argument. It's like, the path of least resistance, let's say. The burden will go to the taxpayer for sure. But when it comes to property, I'm really thinking about, maybe when you talked about in your conversation before, it comes down to certain minimal reductive ideas. I still think of property just for the fact that, the United States, as I understand as a legal framework, is that every square inch of this land is actually defined by property boundaries. Just as a basic understanding, whatever we own as a country or an empire or a framework is demarcated by value, which already in turn helps an economic engine of speculative monies, in the ether, right? So, but again, if you're building a technology on top of other knowledge, that's also property, and there's no compensatory method, it is a theft. It is kind of, and that's why I put definitions of collage. Could you see it as a collage? Could you see it as a mixed media work? Would changing the definition of photography to a certain updated pre-AI generated art be more applicable? Because I think when I reflect on the harm that it's caused, I'm hearing more about we're helping society generally, and we're helping businesses, but I'm not hearing about the human cost of livelihoods. And I'm not sure if that's the burden of the AI company, but it seems as though if they're breaking things, then they should have an ethical or moral responsibility to make things a little bit better at the same time. What are your thoughts about you as a legal scholar thinking through, your job to uphold the structure, which is flawed to begin with, but that's the only one that we have? How do we continue improving it? Right.
Yeah, I mean, this is a very broad set of questions, and I think I agree with you. The kind of, like I said, right, like the artists are the but-for cause of this technology. Without them, we couldn't have it. So surely, and they're being disrupted by it. So on the other hand, it's very easy to move jurisdictions. Much harder. It's much easier to police physical property than it is to police this kind of online property. And while the companies enjoy low tax rates and things like that, ultimately, like if we make it impossible for them to exist in the United States, they'll just move. And it doesn't seem like there's going to be, I mean, this is like bigger politics, right? Like this is kind of above my pay grade, but it's unclear whether that would be a benefit to artists. So I think finding some sort of intermediate solution that like allows the technology to proceed while encouraging the continued artistic expression is kind of what we're hoping for. You asked me how this factors into my work. Like, for the most part, I'm kind of bounded by what the law is, right, and how I expect courts to interpret it. And I think the additional kind of dimension that I bring to it is thinking about how we can kind of embed some of that in technology or kind of like use technology and computation to improve the legal practice. And the legal reality is, you know, in the US, we have this fair use doctrine, and it seems like it's likely that it's going to be applied in some way to generative AI, because you're not, you know, taking the whole work. It's so transformative. There's so many kind of reasons that weigh in favor of that. What I think is, you know, unclear is how we treat infringing outputs, right? So like training the model is fine. Generating certain outputs might raise an issue. But yeah, I mean, if we look at kind of compensatory licensing schemes and stuff, it doesn't tend to be a large amount of money. And then also, you know, if you think about how much does each individual artist contribute, right? Like there's this concept of kind of like, if we remove one artist's works from the training data, like how much would that change it? And like, if that's how they're doing the pricing, like how much are you adding individually? Again, it's not going to be a huge amount, right? Because the kind of the power comes from just having lots and lots of art. So yeah, I worry about just relying. Like, I don't want to live in a world where our ability to have art and new art being created by humans depends on the willingness of AI companies to sponsor that art. That is not the world I want to live in. I think that would be really unfortunate. So
yeah, no, I agree with you. I agree with you.
Yeah.
But just to go back very quickly, I think that, let's say that you had the magic pen and you had the magic donor, you know, the trillionaire. How would you think we need to solve this now? Would it be all of the CEOs of these AI companies, the top scholars, philosophers, politicians? Like, what would need to be the mechanisms to make this type of technology feasible, so that the tool doesn't become the weapon? Because depending on where you see this tool, it's weaponized to take your livelihood. But if you are making a profit, it's the tool that, you know, liberates certain type of evolutionary development of humanity.
You know, this is
what do you think we need?
A cop-out answer, but I would really like to see more like democratic kind of discourse, right? Like, what do the artists think? And the problem is, this is like a greater problem, you know, certain voices are loud and others are quiet, and we don't really know, right? And I would love to kind of, you know, see more education and discourse, and like to make a good decision, even if you had the magic wand, like we kind of need to know how people feel, and there's like different camps.
Of course.
Yeah. So I think, you know, like I said, it's a cop-out answer, but I think that's where I would start.
No, I think
that these kinds of
that's
things
very
are great.
valid. That's very valid. I think that I'm imagining defending these countless people, but I also understand that without the idea of really getting to the root of what is, you know, a large language model, what the code actually does, and what the potential is. Because we had the author of The Coming Wave come to UCSB, and what he talked about is that, you know, he's predicting already GPT-7 or 8, and what he's seen in his works are that every time there's a 10x capacity built into the machine, then there is a new novelty of activities because of relations. But he also said that his view is that when we get to GPT-7, the issues that we have now will kind of flatline, because the intelligence will be built into the large language model, the system. And I thought that was a little bit of a cop-out, because I don't remember in human history when things were democratized and that everyone had equity and equality here. So there's always going to be bias. I don't even understand how you would begin to compute equality. And so how do you see that if you were a legal counsel to one of these big tech AI people? What would you recommend they invest in now so that they can look at the the exponential growth of a ChatGPT 7 or 8 in the future. His idea was containment. That was his big idea in the book.
So I think that, I'll just go off of containment a little bit, because this does present a key question, right? Is the world that we have now, where there's a handful of entities that are really running the models, there's some open source models, but they don't perform as well. And they're not being used by nearly as many people. Is that kind of the world that we're going to be in permanently? Or are we going to move towards a world where kind of anybody with, say, $10 million and some, technical acumen can spin up a really competitive model? Those two worlds look very different in terms of, watermarking, content, with regards to misinformation, with regards to like ensuring that we don't create infringing content. And so I think that's a key question. And then there's like the labor economics, kind of understanding, we have lots of people, lots of scholars who are thinking about this, but it really feels like there is like a possibility of massive changes to the workforce in the next like 10 years driven by these technologies. And like, what does that look like, right? And how do we help educate people about using the tools, continuing to stay, relevant, competitive? Like, what do we need to do to make sure that we don't see kind of like a massive divergence between kind of the folks who have the tools and invested in them early, and everybody else who's kind of losing their jobs? So those are kind of some of the this goes way beyond the legal stuff, but some of the things I think about. Yeah.
Well, the author I was referring to was Mustafa Soliman, and it's The Coming Wave. He's been on a book tour, and but I wanted to really thank you, Robert, for your time, and actually your willingness to really expand your comfort level when it comes to thinking through these topics. I'm always asking the question of how arts and sciences come together, and that's been my role here at UCSB, is literally working with engineers and scientists and really understanding that, at least to my understanding, there isn't, these ethics that are taught within the, computer science fields. It's mostly they need to focus on their studies. But if you go outside of their studies, then that's a waste of time. And I think maybe that could be something that you could suggest, like why don't we have a way that we understand each other, build bridges? But I wanted to thank you very much, Robert. Great time this morning.
Perfect. Thank you so much. Appreciate it.
Well, Robert, if we kind of, you're a victim of your own success. It's such an interesting discussion that you generate all these kind of comments. We want to try and wrap up. There are a whole bunch of questions in the chat. Mikhail, do you want to ask a question? You put your camera on.
Yes. Thank you, Neil. Briefly, thank you, Robert, for this very, very interesting session. I also just really enjoyed the back and forth between you and Gustavo. Well, yeah, I mean, obviously, in the art world, I happen to be an artist myself here in Germany. We have decent support here, although nothing to the best of my knowledge that is implemented because of AI. Maybe that's still a while for that to come, if at all. Well, obviously, yeah, in the art world, that goes back many decades. If we think about appropriation art, and also I was thinking of the late designer Virgil Abloh, who said that you only have to change like 3% of an existing design, and that sort of makes it your own. After he had a couple, I'm sure, lawsuits coming his way, taking that position. But actually, the thing I wanted to you touched upon this, but I wanted to briefly come back to is this question of open source. Now, if we take someone like Jan LeCun, right, who obviously is at Meta. Meta has been recently sort of championing that. And when he goes back to the 90s and takes the example of, let's say, the battle over the web, Sun Microsystems, Microsoft, ultimately it was Apache and Linux that sort of, came out and won the battle. And he says the model that's going to win is the open one. And if we look at, Llama 2 from FAIR or Stable Diffusion, these are fairly powerful. And I'm wondering what your thoughts are. Do we have, because you were mentioning, the sort of the democratic dimension, do we have a right to open source? I mean, does that change the perspective? Does it, yeah, maybe we could go into this a little bit.
Totally, yeah. So we've this tension between, there are benefits to having non-open source here too, and just like flagging those. I don't necessarily think that's better, but just so we're like having the right conversations. If we think that this is dangerous technology, then it's much easier to regulate it if it's, run by a few companies that we can grasp, right? That's essentially the key thing here. On the other hand, especially when it comes to kind of privacy and being able to use proprietary information, it seems like the open source model could actually be the key, because what it means is that you could have your own local version of a model running, say in your design company, right? And it's trained off of your proprietary designs that you've never shown anybody else, that you never want to show anybody else. And then this way you have kind of like a local version. And if it's sufficiently easy to train these models and you don't need a ton of training data to do it, like that could be an interesting solution. OpenAI and is already kind of entering this space by essentially just making the promise, like, look, certain data we won't look at if you give it to us as part of your prompts. So we'll see which model wins out, right? Kind of like the benevolent company that makes legal guarantees, or the kind of cryptographically secure, locally hosted version for this privacy stuff. And there's lots and lots of people who are working on kind of privacy and large language models, privacy and generative AI. So it's like an ongoing thing. Then you have the question of like, okay, but open source has other benefits, right? Too, because it means that more people are working on a technology, it kind of becomes better collaboratively. And this is, I wonder, and I just don't know whether or not this is going to be true for this very data intensive realm of generative AI, right? Because it's, what's definitely happening is that people are contributing data sets, like these supervised data sets. And those are, open, and they're using open source licenses, which, by the way, is an issue for us because open source licenses are not really designed for data. So it raises certain problems. But so that's alive and well, that's happening. We also see models that are open. I think like, is ChatGPT a model or a service? Maybe that's the way to think about it. Like, services don't tend to be open source, software does. And like, maybe we will see open source software here, but not kind of open source services. And maybe to be usable for many people, they'll want a service, right? Which is like a package thing, lots of kind of additional considerations about how we present, the content back to you, additional content moderation, et cetera, et cetera. So it's an interesting question. I don't know. I don't think I answered your question, but maybe I gave you something to think about.
No, thanks, Robert. These are great remarks. I'm thinking about this myself. I mean, in a sense, it's like, as an artist or designer, architect, in a sense, you get a feeling is that there is a tool which we can, if we have the capacity, both, let's say, in terms of hardware and so on and so forth, or knowledge, actually, that we can, if we could, we could change the weights, we could play around with this. It's a tool that is at our disposal, and we can train our own models. I mean, I think you were saying, it's actually not so simple in the end, but the possibility exists. So in terms of that, from this perspective, for me personally, I think there is definitely argument to be made, and I suppose it also maybe changes the sense of which one feels like, how is my own sort of data work used in that regard, if I feel like I'm getting tool sort of back. in a sense, it becomes like an exchange almost, versus the idea that it's okay, it's hidden somewhere in private, some private corporation has, and I have no access to it, no say, and I can maybe, if, pay some money and make some images. Anyway, a complex topic, but I think, yeah, Neil wants to sort of bring this to a close. It's been a super interesting session. Yeah, Neil, do we want to get to some more questions? Thank you, Robert. It's wonderful.
Yeah, just maybe I could just read out some comments in the chat, which are not questions as such, but just to acknowledge them and thank you for posting them. One is from Bibi Biagil, which I think is Bibi Uf, a AI fashion designer from Italy. And here, it is she. Can't afford the idea that artists are used to train models. Doesn't like that idea. And then says, use AI and understand we must have rules, absolutely, but also understanding how to make AI an instrument of fantasy and not of copy. I think now we are over this yet, unfortunately. That's true. We should really be seeing it in terms of the fantasy that it produces. I want to also get down to this Dimitri, who's actually with us. Maybe Dimitri, you don't mind, I can read it out for you. Dimitri's in Shanghai. An interesting to me related topic I wanted to share. One, reopening of forgotten capacities, historical styles, Baroque, Gothic, Art Deco. What we didn't have access to could be part of the regular vocabulary. Dimitri, do you want to maybe say that yourself?
Yes. Thank you for a wonderful session. It was been a great a great information, and I've been seeing a lot of positivity on the side of the law regards for the creation of the new things. As I understand, actually, throughout the listening, the first topic is regards to using the historical styles. I mean, it's kind of the general like a topic about, like, we didn't have opportunity, for example, before to use the Baroque or Gothic because there was extremely how to say, difficult to do in a very fast pace. And right now, there is an opportunity to use them as the study point or as the point to gain some kind of knowledge of what is like formal or aesthetical aspects of the architecture is. And like, how does, like, those guys lies in terms of the like copyrights, for example, the Gothics or Art Deco. Like in Shanghai, it's a quite a big topic, and in Asia, like there is quite a few like new buildings that kind of echo deco, and like this is a one thing, and the second thing is more kind of precise and moral thing about the blending. Like in I mean, at the current stage in the mid-journey, there is a features like a blending or like a descriptions that basically lead us to some kind of type of manipulation, and what kind of things would be moral to blend or not, like in terms of the thing, like do we need to aim for the goal, or we need to kind of purify the inputs somehow? Because if we take like great image and blend it with another great image, we're coming up with a great output, kind of with a very high probability. But on other hand, if we kind of coming up with our great image, or we draw ourselves the great image, and we're using this like a mid-journey for now, like that is not like the topic of necessarily of the like AI, but is more precisely about the mid-journey operation for now, because just how the interface working, like we need to kind of gather the information and stream it back like in a very precise manner, so we are avoiding any kind of thing that we're taking the Gioconda and the amazing like Damien Hirst flowers, and it definitely should be something nice coming up from that. But like what we can use with this kind of functions, yeah, like that is, but that's it's a kind of have I think the moral aspect, and I also don't know the answer for this question, just throwing it. Thank you.
Thank you. Neil, would you like me to respond in light of time, or?
Sure, no, sure, yes, do. But I do want to try and wrap things up fairly soon because I think this is an amazing conversation. But I feel like, lawyers normally put us on the spot, interrogate us. We're putting a lawyer on the spot and we're getting our revenge, as it were. But,
you get your revenge, yeah. Well, I'll just say briefly that, copyright, you talked about the blending, and it's interesting. Like, we usually don't, for example, protect styles. We usually only protect like major elements from a work. And this actually is, I think, a problem when we're applying copyright law here, because it's pretty easy to copy someone's style without copying major elements, right? And like and we've seen people, on Twitter and elsewhere saying, look, like, it's not like a specific work of mine, but like it's copying my style, either in a way that I'm uncomfortable with because I don't think it's doing a very good job, or in a way that I'm uncomfortable with because I've spent decades perfecting this style, and now you can just generate stuff in my style. So this is kind of a challenge, which I think is related to the blending question you've mentioned. Yeah, it's hard. It's hard to find a good solution here.
I was just, for example, I was like trying to seek in the beginning when, like a couple of years ago, when there was the deep dream, and I remember I was just first enough, like opening things, and I kind of didn't know what to do, and like in a manner of like the search, I was kind of taking the thing which is like was LA, the traffic jam, a picture, and the butterfly, and then mix it up, and then I get the butterfly with a like a wing of this kind of like light pollution, like as a wing pattern, and that was like, okay, so that was a test of capacity. But then later on, like within Midjourney, like some version, I have this one experiment, which is I take the image already of the car light, and then I blend it with a flower, and then I get some like really like nice effect. But then I realized that this image lies a lot on the content of the input, and then I basically kind of cancel this idea for myself of kind of getting like something really striking and like get an understanding out of that. And it's not like was presented as a design, as was is kind of item that kind of was trying to expand the knowledge. But then the content of that, like if to start to present it in own presentation, would be saying, okay, I have this kind of idea of this articulations, which is lies on the like bio and like the automotive crafting, and which is like a lot in the Pinterest and stuff like that. And technically, like to expand this new libraries of the aesthetics, it would be like interesting to see what is there. But the content wise, like if there's a lot of great examples of great designs in the Pinterest, especially like as a part of, and like in the companies, they do use that for the references. Like, do we need to update this as a like reference library without anybody's property, let's say, or something like that?
Yeah, I mean, from the copyright perspective, like this kind of blending is probably fine. But that doesn't mean, it's kind of like academics cite each other, even though like, right? Like that's not like a legal thing. It's a community that has come together and said, we want to recognize where knowledge is coming from, and that we stand on the shoulders of giants. And by the way, it's useful to know where your thinking is coming from, right? So, we could imagine, and this would maybe be an interesting kind of feature where when you have an output generated by an AI, it tells you which images contributed the most to that generation. Like that's technically feasible. And even if it's not required by copyright, like maybe that's like good to know, right? And then you could put out this like blended image and say, look, I had this cool idea. Obviously, it relies a lot on the inputs, and I want to recognize those. It's not like copyright infringement, but still, like I realize that like I'm standing on the shoulders of others. So something like that might make sense.
And like, for example, here, we just like briefly coming back to this idea of the historical styles, like, do we like standing on the shoulders of the like Baroque or Gothic when we're doing this like things or not?
So whether we stand on the shoulders of these like classical kind of artistic movements when we're using generative AI today?
Yeah, as they was like before, like in terms of like in a collage, do not provide the articulation that like that before was like able to merge them, and right now it's really possible to merge any kind of stuff, any kind of panels in a very detailed like manner in terms of the like precisions and stuff, and it could be like processed afterwards somehow.
I think it's case by case, right? I mean, some specific works generated by AI will have different kind of styles and provenance than others. On the other hand, you know, because these engines consume so much data, it's kind of like, look, it's where did all of art come from, right? At least all the art that's like capable of being on the internet, and like it's all of it, right? I mean, it's all of it, and so it's on all. We're standing on all the different giants.
Thank you so much.
Let's try and wrap things up. I just briefly one other comment from the chat from someone, Phoenix, who has all caps for some of the words, which clearly he or she feels passionately about this, and I think this subject does, you know, raise lots of passions. My suggestion is this: pass legislation that such that anything, all caps, and I do mean anything, all caps, that is made with AI must carry a symbol or mark saying so. You kind of alluded to that in some of your comments about whether that's feasible or not, but that clearly shows some of the concerns out there. But I think we need to wrap things up. So, Robert, you have this has been an incredible treasure trove of ideas. All I would say is that, you know, I think that it is so important to unpack some of those incredibly dense thoughts in that article, and these last two, the session and the previous one was so good for that. I just wish that there could be a book coming out for that particular article with separate chapters. But I also feel there's a book there, Robert, that's going to be for you to produce, but it's going to be out of date before it's published. I mean, the time you're taking in publishing something means that the publishing's almost become obsolete. I'm in the situation whereby the only way I can do this is by putting QR codes that relate to something that is more contemporary, and you can somehow keep up to speed with it, up to date, because we almost have to have a Google Doc that has been updated for our books on a daily basis. But I just want to leave you with a thought, and this comes out of Gustavo's comment. I think Mustafa Suleyman is really super smart. He's one of the co-founders of DeepMind, and I think one of the great intellectuals in the field. He actually did a PhD at Oxford before he went to the field, so he has a background in philosophy and so on. But I actually do buy his idea that I know that Gustavo, I do buy this idea that actually maybe AI would understand all these systems, and that's what it seems to be able to do. I mean, it seems to have hacked into everything, how to write code, how to translate languages, and I think it might be able to do lots more. But it strikes me, the one issue I think with law, which I think it becomes the tricky thing is the kind of principle, and I'll get my Latin right now, ignorantia juris nemine excusat. In other words, ignorance of the law doesn't excuse anyone, which makes it very difficult for the general public, right? Because how the hell we're going to be educated in the law? Otherwise, we're going to trip up in some way. But then it struck me that actually what maybe we're going to see in the future, and this is kind of like a kind of vague prediction, which might be completely wrong, is to say, I think that actually the logic of spell check is probably going to be the way that AI goes. In other words, it is going to not only spell check, but fact check, and it's going to be able to check, and particularly with fakes and so on, be able to tell us whether it's correct or not. But I also think that they maybe get warnings that are embedded into whatever we type, saying, legally you can't say that, or legally you can't do that, or something, which kind of means that the role of the lawyer as this kind of someone who knows all this knowledge is being displaced by AI in some senses. And I think certainly that lawyers are, and this is something that Richard Susskind has been writing about for years because he's an AI and legal scholar. that the law is going to be one of those areas that is going to be completely transformed by the domain of AI. And I think if it could give us legal warnings for what we're doing wrong, which I suspect it will, it could be extremely useful, although maybe it's kind of taking away the role of the lawyer. Robert, I want to say this has been terrific. This has been really, really wonderful. I kind of predicted this. I thought this was going to be amazing. And all the comments in the chat have just been confirming this. This is something that I think is really goes to show how useful it is, first of all, to generate this article. So I want to thank Ziv and Aaron for expedite making that possible, but also for having a platform where these things can be unpacked and in an intelligent and informed way. And it's no good artists and architects kind of offering their opinions on copyright. We need to hear from those who are real experts. And today we have, and this has been such an insightful, such a useful session. Thank you, Robert. Thank you so much. I mean, it's been, I don't know what to say. It's terrific. And thank you for giving up your Sunday morning. I'm sure there are better things you can be doing in Cambridge right now than this. But from the point of view of the audience, this has been such a contribution. And thank you also to those questions that have come in literally from all over the world. Thank you also to the team behind this setting up, the Digital Futures team, especially Michal in Berlin, but everyone else who puts it together, because this is a selfless task of people giving up their time to support others and share their passion. And you've shared your passion for the law, Robert, and really super informative. I love that. So thank you, Robert, and thank you, everyone else. And next week, we have another session on AI in the future of the office. It's going to be so relevant to architects in particular, but today was a very, very special session. So thank you. This will be uploaded to our YouTube channel. Everyone can see it, and hopefully over the years, it will kind of build up. Thank you. There's amazing comments in the chat. Thank you, Robert. Amazing.
Thank you so much. Thank you so much. This is great.
Thank you.
Thank you, Robert.
Thank you.